Good morning. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, September 11, 2019. The time is 9:30 a.m. With us today are Commissioner Emily Lindley and our General Counsel, Mary Smith. I'm John Neerman, and Ms. Smith, I'll ask you to call the first item.
Item number 1 is consideration of the ALJ's proposal for decision and proposed order concerning the application of Altair Disposal Services, LLC, for new hazardous waste landfill permit number 50407.
So Commissioner Lindley, Senator Colcourse and Representative Lehman's offices wish to speak on this item, and so what I thought I'd do is give them that opportunity in just a moment. I think we have staff from those offices here, and then continue this item to the end of the agenda. That way we don't hold the rest of the agenda captive. I think there's going to be some lengthy discussion on that Altair PFD. I also understand that there were some local news sources that may have indicated that members of the public would have an opportunity to speak on the PFD. That is not the case. The record is closed in that matter, and it's only the parties who will have an opportunity to make presentations, with the exception of the representatives from Senator Colcourse and Representative Lehman's office. As a courtesy, we allow them to address the commission, but of course the record is closed and we can't consider anything outside the record. For those of you who traveled here, thank you for making the trip. Your presence is meaningful, and if you sign in, it will be noted for the record. So with that, is it Mr. Geisinger first? You'll have to correct my pronunciation. And check to see that the light is turned there. Okay, we're good. And just please state your name and affiliation for the record.
Thank you, Mr. Chair, Madam Commissioner. My name is Ross Giesinger. I'm an attorney for State Senator Lois Colcourse. The senators asked me to read a letter on her behalf into the record. Additionally, I have a letter from State Senator Donna Campbell expressing her opposition to the permit as well. Please allow this letter to express my utmost disappointment in the Commission for ignoring the formal request of 3 state senators who, including myself, requested a later docket date to allow us the opportunity to personally take part in today's hearing. This letter must also serve as my office's stringent opposition to the proposed hazardous waste landfill facility permit application number 50407 by Altair Disposal Services, LLC, to dispose of waste from Clean Harbors Incorporated due to the potential for severe contamination to local surface and groundwater resources. Many industries, businesses, and families depend on water from the Colorado River and associated aquifer in the area. As the state senator for Colorado County and the entire lower Colorado Basin, please know that I concur with the administrative law judge's proposal for decision and order on the application, and respectfully request that the commissioners to deny the permit. The large deposits of sand and gravel in the area create a porous, permeable layer of sediment that allows water to migrate between the lower Colorado surface watershed and the Colorado River aquifer and the Gulf Coast aquifer. This water is consumed by many people and animals in the vicinity of the proposed landfill, including rural households, local towns and communities, and the Rice Consolidated Independent School District. Additionally, downstream farmers rely on the water from irrigation intakes located just downstream from the proposed site. Were a hazardous spill to occur, the resulting damage could affect hundreds of square miles of farmland and communities. The porous nature of the sediment could allow contaminants to migrate into the aquifer, damaging it for years to come. The lower Colorado River Basin has experienced 4 major flood events since 2015, including Hurricane Harvey. This has exacerbated efforts by local entities to maintain water quality and flood protection in an area that already receives some of the highest annual rainfall totals in the state of Texas. Furthermore, the recent events along Skull Creek show just how unsuitable this type of geography is for waste disposal. Time and again, the weather and geography along the lower Colorado has shown that it is an unsuitable location for a hazardous waste disposal site. There are many other sites, some located closer to the Deer Park production facility, that could serve as alternatives. Finally, we must draw attention to the fact that a hazardous waste disposal facility has been previously proposed at this location and was not approved by this very commission when it was known as the Texas Natural Resources Conservation Commission. I fail to see any changes in geography that would cause the commission to reverse its earlier ruling. In closing, this process has yielded many disappointments for me, and I hope today for the health and safety of everyone living in the lower Colorado River Basin. I ask the Commission to accept the findings of the Administrative Law Judge's proposal for decision and order and reject the permit. We must remember that the state's job is to protect the environment, not a flawed waste disposal plan. On behalf of Senator Campbell, please share my concerns to the TCEQ regarding a proposed landfill in Colorado County. The groundwater that flows through these sand and gravel layers serves as a potential source of water for livestock, rural households, the town of Altair, Forest Oak Water Supply Corporation, and Rice Consolidated Independent School Districts, all located in the immediate vicinity of the landfill. In addition, the Lower Colorado River Authority intakes on the Colorado River for the Lakeside and Garwood irrigation districts are immediately downstream of the proposed hazardous waste site, further threatening to distribute a spill event across hundreds of square miles of rice-based agriculture and directly above large areas of the Gulf Coast aquifer. The Lower Colorado River Basin has experienced 4 severe flood events since May 2015, further heightening concerns in an area that receives close to 50 inches of rainfall on average and localized large rainfall events. I respectfully ask the Commission to consider and accept the findings of the Administrative Law Judge's proposal for decision and order regarding the application and reject the permit in order to protect the long-term health and vitality of the groundwater and the Colorado River and Matagorda Bay.
Thank you, Mr. Giesinger, and please thank Senators Colcourse and Campbell for us.
I will. Thank you for letting me speak.
Thank you. Mr. Starnes.
Thank you and good morning. Dear Mr. Chairman, members, and staff of the Commission, my name is Wesley Starnes. I'm Chief of Staff for State Representative Ben Lamont of House District 13. Representative Lamont asked that I present today his letter of opposition to the Altair Disposal Services, LLC Hazardous Waste Landfill Facility Permit number 50407. Instead of reading the letter in, verbatim, with your permission, I'll just read the letter in part and then summarize the rest.
Sure.
As State Representative of House District 13, which includes Colorado County, where the proposed permit is being considered, I discourage you from approving item number 1 on today's agenda. I'm sorry that I'm unable to attend today's hearing, but wish to express the concerns of the constituents in my district via this letter. The groundwater that flows through the sand and the gravel layers serves as a source of water for livestock, rural households, the town of Altair, Forest Oak Water Supply Corporation, and Rice Consolidated Independent School District, all located in the immediate vicinity of the landfill. The State Office of Administrative Hearings, SOA, reviewed Altair's Services LLC Hazardous Waste Landfill Facility Permit application extensively. I concur with the Administrative Law Judge's decision concerning the application and respectfully request the permit be denied. Based on the findings of SOA, we know the application does not meet the safety and requirements set in place and established by the Texas Health and Safety Code and the Texas Administrative Code. The potential adverse impacts of the lower Colorado River watershed and the associated shallow Colorado River aquifer, the Gulf Coast aquifer, the additional lands, businesses, residential properties, and industries that rely on the water from the Colorado River would no doubt be put in jeopardy if this application permit is granted. Therefore, in closing, I again ask that you not approve this permit application and deny it in its entirety. Sincerely, Ben Lamont, State Representative District of House District 13. Thank you so much.
Thank you, Mr. Starnes, and please thank Representative Lehman for us. And with that, we will continue item 1 to the end of the agenda. Ms. Smith, please call the second item.
Item number 2 is the application by Austin Asphalt Incorporated for renewal of air permit number 76338L002. The parties have been notified that the commissioners will not take oral argument but may ask questions. We have some members of the public that were signed in on this item, and their presence will be noted for the record.
Commissioner Lindley, on this one, it's a no increase renewal. The applicant has a satisfactory compliance history, so under Texas Health and Safety Code 382.056, we cannot grant a contested case hearing. There is also a pair of requests for reconsideration on this matter. I'm not sure that they're appropriate procedurally, but if they are, we're compelled to deny those for the same reason.
I would agree that the hearing request and the request for consideration should be denied today. And with
I'll
that,
entertain a motion.
okay. I move that we find that no right to a hearing exists on the application, that we deny the hearing request, that we deny the request for consideration to the extent their filing is authorized under the Commission's rules, grant the renewal of air quality permit number 76338L002 to Austin Asphalt Incorporated, recommended by the Executive Director, and adopt the Executive Director's response to comments.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries.
Item number 3 is the appointment of 5 nominees as members and the appointment of a current member as chairman of the Municipal Solid Waste Management and Resource Recovery Advisory Council. The Executive Director's staff is here to present the item.
Good morning.
Good morning, Mr. Chairman, Commissioner, General Counsel, and the Public Interest Council. My name is Anju Chales of the West Permits Division. With me is Sia Persson from Environmental Law Division. We're here requesting the appointment of 5 new members to the Municipal Solid Waste Management and Resource Recovery Advisory Council. We also request the appointment of a president to the Advisory Council. This Advisory Council is composed of 18 members who review municipal solid waste management policies and make recommendation to the Executive Director and Commission. Executive Director staff published the request for nomination on May 3rd, 2019, and extended the nomination period for 2 weeks until June 18th. A total of 13 applications were received for 6 specific qualifying positions. Staff has reviewed the application received to ensure compliance with statutory requirements for each vacant position. In your materials, you have a listing of vacant position and biographical information of the applicants. Thank you for consideration of this matter. We are available to answer any question at this time.
Thank you. I have none. Commissioner Lindley?
I have no questions. I'm comfortable with I'll let OPEC speak.
Mr. McWhorter?
OPIC recommends approval of the resolution appointing these 5 members to the Municipal Solid Waste Management and Resource Recovery Advisory Council as presented by the Executive Director.
I agree. I think it's appropriate to go ahead with these appointments, and I do want to thank all the nominees for their willingness to serve, and in particular, Ms. Weinberger, Mr. Dillard, Yankee, Trebus, and Perez. I also want to thank Mr. Holder for his past service and his willingness to serve as president. I'm sure they'll all do a great job in those capacities.
I
With that,
agree.
I'll entertain a motion.
Yeah, and I would just echo that with thanks for staff for vetting the applications and doing that. So with that, I move that we appoint the following nominees to the Municipal Solid Waste Management and Resource Recovery Advisory Council. 1, David Dillard as an elected official from a municipality with a population fewer than 25,000 to expire August 31st, 2023. David Yankee is a representative of the financial community to expire August 31st, 2025. Risa Weinberger is a person who is experienced in the management and operation of a composting or recycling facility, or an educator with knowledge of the design and management of solid waste facilities to expire August 31st, 2025. Number 4, Scott Trebus, engineer, is a representative from a solid waste management organization composed primarily of commercial operators to expire August 31st, 2025. And number 5, Trent Perez is an elected official from a municipality with a population between 100,000 or more, but less than 750,000, to expire August 31st, 2025, and that we appoint the current advisory council member Robert Holder, PE, as advisory council president to expire August 31st, 2021.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries. Thank you.
Item number 4 is the discussion of the Office of Public Interest Counsel's annual report, and OPIC is here to present the item.
Mr. McWhorter?
Good morning.
Good morning.
Texas Water Code Section 5.2725 directs OPIC to report to you annually concerning OPIC's performance, our budget needs, and recommendations we have for statutory or regulatory changes. The written report in your agenda backup is intended to satisfy that statutory directive. At pages 6 and 7, the report lays out OPIC's performance measures adopted by the Commission in 2012. At pages 7 and 8, we provide fiscal year 2019 information related to the 4 types of matters we are required to measure, which are environmental matters including permitting, district matters, rulemaking, and enforcement. At pages 9 to 12, we have the required section about budget needs. Finally, the report this year has no legislative recommendations, but we did include some proposals for regulatory changes at pages 12 through 25. Thank you for consideration of the report, and I welcome any feedback or questions you may have.
No questions, but in terms of feedback, I appreciate the report. I appreciate the recommendations. I think we'll consider those as that process takes shape. Appreciate the job that you and your team do. And Commissioner Lindley?
I ditto those comments. Appreciate the report and appreciate everything y'all do.
So there's no action
Yeah,
necessary
we
on
do.
this, so thank you.
Thanks, Vic.
And that will take us to the enforcement docket, items 5 through 22. The executive director's staff is here to present the matters, and I'll note that on items 6 and 22, we have individuals who have signed in but indicated that they don't wish to speak, and their presence will be noted for the record.
Good morning.
Good morning, Chairman, Commissioner, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell from the Enforcement Division, and with me today are Brian Sinclair, also of the Enforcement Division, and Charmaine Backens and Janice Hernandez of the Litigation Division, representing the Executive Director. Pending before you are items 5 through 22. The total assessed administrative penalties are $462,391, with $36,959 deferred, $195,040 applied towards supplemental environmental projects, and $230,392 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you. I have none. Commissioner Lindley?
I have no questions either.
Mr. McWhorter?
My office reviewed these items, and we recommend approval of the proposed orders as presented by the ED.
And I agree. And Commissioner Lindley, if you agree, I'll entertain a motion.
I agree. I move that we adopt items 5 through 22 as recommended today by the Executive Director.
The motion has been made. I second it. All those in favor say aye. Aye. The motion carries. Thank you.
Item number 23 is the consideration for publication of and hearings on proposed amendments to 30 TAC sections 117.10, 117.400, 117.403, 117.8000, and 117.9030, control of air pollution from nitrogen compounds and corresponding revisions to the state implementation plan. The Executive Director's staff is here to present the item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Javier Galvan with the Air Quality Division. With me is Amy Browning with the Environmental Law Division. For your consideration today are the Executive Director's proposed revisions to 30 Texas Administrative Code, Chapter 117, Item 23, to implement reasonably available control technology requirements for the Dallas-Fort Worth area based on a serious classification under the 2008 8-hour ozone standard. In addition, the proposed amendments will clarify the applicability of operating hours restrictions for exempt stationary diesel and dual fuel engines in Section 117.403. The proposed amendments would also update allowed emission test methods for stationary internal combustion engines in Section 117.8000. Staff also respectfully requests permission to make non-substantive revisions to comply with Texas Register requirements. Thank you. We are available to answer any questions.
Yeah, I'm scratching my head a little bit here. I heard you say DFW. I thought did this item include Houston, Galveston, Brazoria as well?
Yes, correct,
Okay.
to address the reclassifications for the two ozone non-attainment areas.
Right, okay, I just missed that. I don't have any other questions. Commissioner Lindley?
No questions, thank you.
Mr. McWhorter?
OPIC recommends approval for publication of and hearing on the rulemaking amendments for these chapters as presented by the Executive Director.
I agree, and I think we should go ahead and publish this proposal.
I agree. I move that we approve for publication of and hearing on proposed amendments to section 117.10, 117.400, 117.403, 117.8000, and 117.9030 of 30 TAC Chapter 117, Control of Air Pollution from Nitrogen Compounds, and corresponding revisions to the state implementation plan as recommended by the Executive Director.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries.
Item number 24 is consideration for publication of and hearing on proposed amendments to 30 TAC Sections 115.10, 115.111, 115.112, 115.119, and 115.421, Control of Air Pollution from Volatile Organic Compounds, and corresponding revisions to the State Implementation Plan, and the Executive Director's staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Graham Bates with the Air Quality Division. With me is Amy Browning with the Environmental Law Division. For your consideration today, we are the Executive Director's proposed revisions to 30 Texas Administrative Code, Chapter 115, Item 24, to implement reasonably available control technology requirements for the Dallas-Fort Worth area based on a serious classification under the 2008 8-hour ozone standard. In addition, the proposed amendments would include technical revisions intended to correct inadvertent errors in Subchapter E, Division 2. Staff also respectfully requests permission to make non-substantive revisions to comply with Texas Register requirements. Thank you. We are available to answer any questions.
I have none. Commissioner Lindley?
I don't have any questions either, thanks.
Mr. McWhorter?
OPIC recommends approval for publication of and hearing on the rulemaking for amendments to Chapter 115 and corresponding SIP revisions as presented by the Executive Director.
I agree. I think we should publish
Agree.
this proposal.
Yep, well, see y'all in March. I move that we approve for publication of and hearing on proposed amendments to section 115.10, 115.111, 115.112, 115.119, and 115.421 of 30 Texas Administrative Code, Chapter 115, Control of Air Pollution from I can't talk today. It's already starting. Volatile organic compounds and corresponding revisions to the state implementation plan as recommended by the Executive Director.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries.
Items 25 through 27 will be taken up together. They are the consideration for publication and hearing on the Houston Galveston Brazoria Attainment Demonstration State Implementation Plan Revision, the Dallas Fort Worth Serious Classification Attainment Demonstration State Implementation Plan Revision, and the Dallas Fort Worth and Houston Galveston Brazoria Serious Classification Reasonable Further Progress State Implementation Plan Revision for the 2008 8-hour ozone national ambient air quality standard. The Executive Director's staff is here to present the item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Kristen Jacobson with the Air Quality Division. With me are Terry Salem and John Minter with the Environmental Law Division. For your consideration today are the Executive Director's proposed revisions to the State Implementation Plan, items 25, 26, and 27, to address attainment demonstration and reasonable further progress requirements for the Dallas-Fort Worth and Houston-Galveston-Brazoria ozone non-attainment areas under a serious classification for the 2008 8-hour ozone standard. Staff respectfully requests permission to publish the proposed SIP revisions, solicit public comment, and hold public hearings. Thank you, and we are available to answer any questions.
Thank you. I have none. Commissioner Lindley?
No questions, thank you.
Mr. McWhorter?
OPIC recommends approval for publication of and hearing on these proposed SIP revisions as presented by the Executive Director.
I agree, and I'll entertain a motion.
I would agree. I move that we approve for publication and hearing on the Houston-Galveston Missouri Attainment Demonstration State Implementation Plan Revision, the Dallas-Fort Worth Serious Classification Attainment Demonstration State Implementation Plan Revision, and the Dallas-Fort Worth and Houston-Galveston Missouri Serious Classification Reasonable Further Progress State Implementation Plan Revision as recommended by the Executive Director.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries. Thank you.
Items 28 through 32 are the quadrennial rule reviews for chapters 35, 101, 113, 301, and 324 of Title 30 Texas Administrative Code. The Executive Director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioner, General Counsel, and Public Interest Counsel. For the record, my name is Patricia Duran with the General Law Division, and with me this morning is Janice Hudson with the Environmental Law Division, representing the Executive Director. Pending before you are items 28 through 32, the adopted rules reviews of 30 TAC chapters 35, 101, 113, 301, and 324. As required by Texas Government Code Section 2001.039, Executive Director's staff conducted rule reviews of these chapters to determine if the need for the rules within these chapters continued to exist. Excuse me. The proposed notices of the reviews were published in the Texas Register in March 2019 with a 30-day minimum comment period. No comments were received during the public comment period for these reviews. Based on the review of these chapters, the Executive Director has determined that the reasons for the rules continue to exist. Additionally, in the course of these reviews, the Executive Director determined that the following are obsolete and no longer needed and will be addressed in a future rulemaking action. Section 101.23, titled Alternate Emission Reduction Bubble Policy. The review determined that the alternative compliance methods are available for most Title V rules. Therefore, relief provided under Section 101.23 would likely not be needed or desired. Rules in Subchapter H, Division 7, Clean Air Interstate Rules. The rule review determined that since the United States Environmental Protection Agency replaced Clean Air Interstate Rules with cross-state air pollution rules in 2011, the rules in Subchapter H, Division 7 are no longer needed. We respectfully recommend approval of the adoption of the Rules Review 30 TAC Chapters 35, 101, 113, 301, and 324. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. Project managers and attorneys are with us today to answer any questions you may have.
I have none. Commissioner Lindley?
No questions, thank you.
Mr. McWhorter?
OPIC recommends approval of these quad reviews and readoption of these chapters as presented by the Executive Director.
And I agree. Commissioner Lindley, I move that we adopt the rule reviews and readopt the rules in 30 Texas Administrative Code Chapters 35, 101, 113, 301, and 324 without amendment, and that we direct the Executive Director to initiate a rulemaking to eliminate the obsolete subchapters and sections identified by the Executive Director in 30 Texas Administrative Code Chapter 101 before the next quadrennial rule review of that chapter.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Motion carries. Thank you.
Thank you.
And Ms. Smith, with that, let's return to the first item, if you'll recall that, please.
Item number 1 is the consideration of the ALJ's proposal for decision and proposed order concerning the application of Altair Disposal Services, LLC, for new hazardous waste landfill permit number 50407. And we have many members of the public in attendance today who've requested to speak on this item or who wanted their presence noted for the record. Again, because the public comment period is closed and the record on the matter is closed, the Commission may not consider these public comments at this meeting, but their presence will be noted for the record. So with that, the order of presentation should be the applicant should go first, followed by the protestants, the executive director, and then OPIC. On August 23rd, 2019, the parties were notified of the following oral argument time limits. The applicant has 15 minutes. The protestants have 15 minutes collectively. The executive director has 8 minutes, and OPIC has 8 minutes. And the applicant may save time for rebuttal as it bears the burden of proof on the application.
Mr. Seal, we'll hear from you first. Good morning.
Thank you, Mr. Chairman, Commissioner, General Counsel. For the record, I'm Derek Seal. I'm an attorney with Winstead PC on behalf of Altair Disposal Services, LLC. As you know, Altair is a wholly owned subsidiary of Clean Harbors, Inc. And here with me today, I have Regional Senior Vice President Bill Hallman here. I've also got Mark Wilson, who's the manager of the existing Altair site. Mr. Scott Graves with Geosyntec, who's the engineer of record, is here, as is Dr. Bruce Darling, who is the geologist of record for this case. In general, the post-hearing briefing and exceptions and replies to the PFD were extensive. The documents filed by Altair and the executive director explain why the great weight of the evidentiary record supports issuance of Altair's application. What I'd like to do is present a high-level overview of the major issues where Altair agrees or disagrees with the proposal for decision, and then if I have time, I'd like to save that for rebuttal. First, Altair's proposed landfill would be non-commercial. It's undisputed in the record that the ED advised Altair to file the application as one for a non-commercial captive facility. A plain reading of TCEQ's rules supports the non-commercial captive nature of the facility. This has never been unclear to either Altair or the executive director. Altair is not receiving waste for a charge from third-party commercial customers. And this is reading through some of the elements in the particular rules that define what a non-commercial and what a captive facility are. Even if Altair received waste for a charge, Altair could only receive waste from other Clean Harbor entities owned or controlled by Clean Harbors, Inc. This is the same person that owns and controls Altair, so Altair is captive to Clean Harbors. The Clean Harbors Deer Park incinerator is the only generator and the only point of generation of the only hazardous waste that Altair could receive. Again, this has never been unclear to either Altair or the executive director. It's important to note that TCEQ's permitting requirements for a commercial versus a non-commercial facility are actually nearly identical. Site selection and location restrictions are exactly the same, with the exception of some floodplain issues and buffer zone restrictions that aren't applicable here. That's from 335.204 E and 335.205A. Groundwater protection and monitoring requirements are exactly the same. That's from 335.158 and 335.163 and 164. Landfill design and operating criteria are exactly the same, 335.173. Closure and post-closure care criteria are exactly the same, 335.174. There are some differences, however, and some of those differences are a commercial facility is required to conduct an analysis of burdens on public roadways, and we're also a commercial facility is required to address emergency response capabilities. And with regard to these different requirements, I think it's worthwhile to put a little perspective on the differences between Altair's facility and a non-commercial facility. Altair, the record shows that Altair would receive waste from only 10 trucks per day. That represents less than 0.5% of all the highway traffic on Highway 71, which runs past Altair. Transportation risks have not been ignored. They have been prominently addressed by the U.S. Department of Transportation in their requirements. And the record shows that transportation of this waste in these 10 trucks is actually highly regulated. The second issue is with regard to the alternatives, and this goes back to TCEQ's rule at 335.205. The executive director, I think, concisely explained in closing arguments that, and I quote, there was much testimony about the extent of analysis regarding alternatives. The record's clear that TCEQ's application form doesn't require an alternatives analysis, nor was Altair ever requested to produce a formal alternatives analysis, nor does the rule require a formal written alternatives analysis. It's also undisputed that in the entire state of Texas, there are only 2 other facilities that can handle this waste, only 2 others in the entire state. Those two sites are 250 and 500 miles away from the Clean Harbors Deer Park incinerator, which is the only source of the hazardous waste. Compare that to Altair, which is only 100 miles away. Although the record does reflect a facility in Louisiana, to be fair, that's 130 miles away, there was testimony in the record that this is not an alternative for a variety of reasons, including the extra distance, liability risks, and there's some other things in there, but those are the two I wanted to point out to you. Third, Altair's proposed site meets the location standards relating to geology. TCEQ rules require a minimum of 10 feet of material, in this case soil, with a hydraulic conductivity toward the underlying aquifer of not greater than 10 to the minus 7th centimeters per second. The 10 feet is measured from the bottom or from the base of the containment structure, and that containment structure consists of several liners. There's a geotextile liner, there's a primary liner system, and there's a secondary composite liner system. So the 10 feet is below an already redundant liner system. The record includes data from 63 hydraulic conductivity tests conducted on 44 soil borings in the landfill footprint. And that's just in the landfill footprint, not at the rest of the site. These soils in the soil formation are described as the Beaumont clay throughout Dr. Darling's testimony. Not surprisingly, the hydraulic conductivity test indicated a range of hydraulic conductivities. Dr. Darling, who is a licensed geologist in Texas and Louisiana, he has over 35 years of experience in geology and specific experience with TCEQ landfill applications. He made it abundantly clear that this type of range of hydraulic conductivity is normal and it's expected. In fact, similar ranges have been deemed acceptable for at least two other TCEQ hazardous waste landfill applications, and one of them would be the Deer Park landfill that Laidlaw was permitted for in U.S. Ecology. In particular, like the Altair site, those other sites are located in the same Beaumont clay formation. They have clays, sandy clays, sand lenses, and they also have some caliche. TCEQ guidance expressly states a suitable site can have variable soils, including seams, sand lenses, and then beds of sand or silt that extend for short distances but that are surrounded by clay. That's what we have here. So if you take the range of hydraulic conductivity data from the landfill footprint, not from the entire site, from the landfill footprint, and you apply the geometric mean, as Dr. Darling did, it shows that TCEQ standard of 10 to the minus 7th centimeters per second is met. Dr. Darling made it clear that the geometric mean is commonly used by geologists to calculate hydraulic conductivity. It's not something new. Further, the executive director provided evidence that they rely on a variety of ways to evaluate hydraulic conductivity, including the geometric mean. In fact, TCEQ actually used the geometric mean for the hazardous waste landfill application for waste control specialists. Even the additional soil boring program that the aligned protestants were allowed to conduct didn't change the variabilities indicated within the landfill footprint. This is the case even though Dr. Darling believes, as he testified, that the additional soil boring program was not really to characterize the site, but to go and find sand and then test it. There was a lot of evidence about caliche that I mentioned earlier. The record shows that the caliche present at the site is impermeable if it's not disturbed. In fact, during drilling activities, Dr. Darling testified that the caliche was so hard that some of the Shelby tubes couldn't be advanced through the caliche layer to even take a sample. With regard to the prior permit applications that I know you've heard a lot about and you've read a lot about, the prior permit application for, it was application number 39093, would have expanded the existing MSW facility in the southern part of the entire Altair site. That's not probative to this case. First, there's already an MSW landfill operating down there. Second, if you compare the geology in that part of the site to the geology beneath the landfill footprint, it's an apples to oranges comparison. The thickness of the Beaumont clay in the southern part of the site for this application is 10 feet thick, compared to the 20 to 25 foot thickness in the vicinity of Altair's landfill footprint for this application. I want to talk a second about Darmore's motion for judicial notice of a SOA order from the prior landfill application for permit 39096, which is a little bit closer to Altair's proposed site. There's no evidence in the record with regard to why this application was remanded or withdrawn. So to suggest that this case speaks anything to location standards is, in my opinion, an exaggeration. The order itself that the motion is the subject of the underlying motion doesn't say anything about location standards. Order doesn't say anything probative at all. And for the reasons stated in our response, we would ask that the commissioners deny that motion. I want to talk a little bit about sand. The presence of sand indicated in the soil boring data is not necessarily an indication that the soil is permeable or impermeable. Dr. Darling testified that, and I'll quote him for a second here, the Beaumont clay unit hydraulic conductivities of significance are not those of the thin, discontinuous accumulations of sand, but those of the dominantly fat clay and lean clay deposits in which the sands are encased. In all cases where the deposits of sand were encountered, the deposits were thin, of limited lateral extent, not connected with other sands, and dry. And he went on to say that the limiting factor is the clay surrounding the sand, not the sand. And he also went on in other parts of his testimony to make it clear that it is the clay matrix around the sand that limits the permeability. That's the limiting factor, not the sand itself. Dr. Darling never saw any evidence of vertical conductivity. Altair's burden here, in the cases we've cited in our briefs, is not to disprove any allegation raised by the protestants. We believe we've done so here, however. I will point out, with regard to geology, Mr. Graves, he's got 25 years of experience. He's licensed in Texas and as an engineer and in 10 other states. He's worked on 40 landfill facilities, and he's prepared 30 engineered designs. He evaluated every soil boring within the landfill footprint to make sure that there was the 10-foot standard that's required by TCEQ rules. The testimony that he provided in his pre-file testimony was not challenged with regard to whether he conducted that analysis correctly. So despite discrete parts of testimony that you may have seen that I believe has been taken out of context, and I may get back to that in rebuttal, every single soil boring was analyzed and evaluated by Dr. Graves, or by Dr. Darling and Mr. Graves. They looked at it to make sure that there was 10 foot of acceptable soil there, and that was their conclusion. The fourth issue I want to talk about is the waste analysis plan and the waste characterization. This is a requirement of 305.50A9. Clean Harbors, who is the only entity that can send waste to Altair under the application, would have already determined whether the waste streams could be accepted at Altair before they ship it. All incoming waste will have been chemically sampled, analyzed, treated, and certified by Clean Harbors to meet the federal land disposal restrictions prior to arrival. The hazardous waste stream generated at Clean Harbors Deer Park incinerator is already being generated and disposed of at the Deer Park facility. That waste stream is well known. Anything in a waste analysis plan and everything required for a waste characterization will meet TCEQ's requirements. There is no regulatory requirement for an on-site waste analysis. Fifth, Altair's application addresses every applicable requirement relating to traffic, transportation, and land use. And there again, because we're a non-commercial facility, we were not required or asked to conduct an analysis of burden on public roadways or an emergency response plan. Based on express rule language and preamble language, Altair provided information regarding major routes of travel in the vicinity of the facility, including a map of land use patterns within a 5-mile radius. That's exactly what's required by your rules in 305.50A10 and 335.181. With regard to the motion for cost reimbursement, we'll let our response speak for itself. Then explains why that motion should be denied. And in closing, for the reasons explained in the post-hearing briefing and exceptions in replies to the PFD that Altair and the executive director have filed, Altair's application meets TCEQ's requirements. Altair provided all of the information and conducted every evaluation required by TCEQ's application form and is requested by the ED. We would ask the commission to either adopt Altair's proposed findings of fact and conclusions of law, which we submitted to the ALJs on February 8, or to incorporate the executive director's recommended changes that they laid out in their exceptions. And we would ask that you grant our application for those reasons. I'm happy to answer questions now or wait till after rebuttal.
Thank you. I have no questions. Commissioner Lindley?
No questions, thank you.
Thank you, Mr. Seal. And we'll hear next from the protestants. Mr. Brown, good morning.
Good morning, Commissioner Lindley, Chairman Neerman, General Counsel Ms. Smith. My name is Kelly Brown today. I'm here representing the aligned protestants, which include Colorado County Groundwater Conservation District, and ACE, which is the Alliance for a Clean Environment Local Citizens Group. And with me today are Judge Daniel Ty Prowsey for Colorado County, County Attorney Jay Johans, County Commissioner Tommy Hahn, Doug Wessels. We've got Jim Brasher from the Conservation District, President Travis Wagendorf, Ms. Mickey Morris, the Attorney for Rice Independent School District, Bill Hefter, the Superintendent for the school district, and Mike Lanier, the President of the Citizens Group, present today. Not surprisingly, the protestants disagree with Mr. Seal's characterization, and we strongly recommend that believe that the administrative law judges got it right. From December 6th to December 18th, there was an evidentiary hearing where all those arguments were made and rejected in whole. And the ALJs recommended denial of the permit. They've issued their proposed findings of fact, conclusions of law, and we recommend that the commission adopt it. We would disagree too with the characterization that the prior two applications that he referenced in the 90s, this is the same geology that was presented and rejected by TCEQ or its predecessor 2 times before. When the application was filed in 2013, they used the same data points they used in their prior failed applications. In the public meeting, everyone in Colorado County is opposed to this. Sand and gravel minings in the neighborhood. We've got vital surface and groundwater resources. In March of 2016, October of 2016, we had a public hearing at Columbus High School, filled to the brim, all in opposition. We had an initial public hearing held in the district courtroom of Colorado County, and in March of 18, that was filled. And I'm going to cede my time to my law partner, Mr. Morris, in a minute, but I wanted to read a couple of things. Texas Health and Safety Code, Texas Solid Waste Disposal Act, Chapter 361 of the Health and Safety Code speaks to the policy. It is this state's policy and the purpose of this chapter to safeguard the health, welfare, and physical property of the people and to protect the environment by controlling the management of solid waste, including accounting for hazardous waste that is generated. We believe the ALJ's PFD does just that and ask that you deny the permit. In fact, TCEQ's own mission statement states the following: the Texas Commission on Environmental Quality strives to protect our state's public health, natural resources consistent with sustainable economic development. Our goal is clean air, clean water, and the safe management of waste. We urge you to adopt the PFD, including the findings of fact and conclusions of law.
Thank you,
With that, I cede my time to Mr. Morris.
Thank you, Mr. Brown. Good morning, Mr. Morris.
Good morning, Mr. Chairman, Commissioner Lindley, Councilor Smith. My name is Robin Morse. I also represent the same parties that Mr. Brown went through, so I won't take my limited time going through that again. But needless to say, as Mr. Brown indicated, we have a diametrically opposed view of the evidence and one that aligns with the ALJs when they wrote their rather extensive and very detailed PFD for this commission. In fact, if you look at their summary on page 2, I think if we go forward on the this one right here, they say the application does not comply with a number of requirements. There were no less than 7 independent reasons why this application could be or should be denied. The commercial versus non-commercial item, we thought that was important. A lot of hearing time spent on that. We do think that this is basically a commercial operation where Clean Harbors, who runs a commercial facility in Deer Park, Texas, charges for its services. The landfill that this landfill would replace, it's nearing capacity, would be relocated 100 miles to Colorado County. And presto changeo, they want to take the position that now that's non-commercial, even though the current commercial landfill is regulated under this agency's permit as a commercial facility. That just doesn't wash. This is an independent company, Altair, a for-profit company that maintains through the parent company, Clean Harbors, a debit-credit arrangement. There's no requirement that a charge be based on cash. Ultimately, the cash that pays for this comes from Clean Harbors customers. So you can trace the money. This is a commercial operation. The geology is a very important thing, and one that even the Altair witnesses, Dr. Darling, we had to push and overcome an objection to take more samples in 2018. That's the crux of our motion for cost reimbursement under the statute. Altair opposed that. Ultimately, the ALJs ordered that that testing be done. It was done. 4 of the 7 borings that were tested showed to be above the standard. We heard a lot of information and argument about how there's no connective sand lens. That's not the point. The point is whether you meet these regulations. And there's stringent regulations, which in the preamble, if we go forward a few squares, keep going. Let me stop here. This is the area we're talking about. This is an exhibit. You see all the extensive sand and gravel mining. Altair would apparently have you believe that this island of clay was sufficient when the whole area is sand and gravel mining with a valuable regional aquifer underneath. If we could go forward, please. Keep going, keep going. Here is the siting standards. It says extreme importance to meet these standards, to have a continuous feature, to minimize possible contamination, to have a minimum thickness of 10 feet. Mr. Darling, Dr. Darling, he prefers Mr., as he said at the hearing, recognized in a number of these samples they were primarily sand and did not meet this standard. Their own witness admitted that they fell short. Next page, please. The purpose is to prevent leachate. This rule, by the way, assumes that you have a release through the liners into the underlying geology. This is a backup, but it's very important under your regulations from 1984 that it not come into direct contact with permeable soil materials. It does, as recognized in several of the borings, a number of the borings, where Dr. Darling admitted that the borings, even though they could have drilled more, they split samples with us in 2018. Those results showed a failure to meet the standard in a number of locations. Even if they met 335-204, that's the 10 to the minus 7 rule. You then have to go to 335-203, which is the second step of compliance. If the stratigraphic profile and the complexities and the groundwater conditions are such that this is not a very good location, then the commission should deny it on that basis. We submit this is exactly such a situation in that the Bureau of Economic Geology, and this was in evidence, had determined that this whole area was not suitable for waste disposal. They try and use geometric means to say that the site was meeting the standard. However, it's very important to note that Dr. Darling himself, when applying an arithmetic average, the average of all the samples through the footnote, or through the footprint, I should say, was above the standard, 2.43 times 10 to the minus 7. So the average of all their samples was above the standard. As Mr. Brown indicated, that this same location basically is recognized by Mr. Graves was basically the same as what was rejected twice by this agency in the 1990s. And in fact, this 2013 application, when it was originally filed, they didn't go out and drill new holes. They used the same 1990s data and tried to make it work here. A few more samples were drilled, most of them outside the footprint. Finally, in 2018, based on the protestants' motion, we were able to drill more in the central part of the site. And those, as I indicated, the majority of those borings that were tested were above the standard. Now, an alternate facility, and looks like I have 1 minute left, the alternate facility thing, I think it's important to note there that there was nothing in the application at all about alternate facility analysis. And when Altair's witness, Mr. Nielsen, who was managing the project, was asked if there was an alternate facility analysis, he said no. And as the Altair official in charge of the application, did anybody else do it? No. When Mr. Venkat, the TCQ engineer, was asked about it, he said, we did not evaluate that. So the bottom line is this was totally overlooked in this application, and it was admitted during the hearing that there was no alternate facility analysis, and we have a facility that we showed, it's not our burden, but we showed there's a facility operating that is fully permitted in Lake Charles, Louisiana, 130 miles, where you don't have to cross metropolitan Houston to get it to Altair.
And I'll ask you to wrap up, Mr. Morse.
Okay. Those are our main points I think we wanted to get across today. We feel that the geology is entirely unsuitable, that there is in fact an alternate facility, even though it wasn't our burden, and that this really is a commercial activity. Thank you, and I'll stand here for questions or come back and answer them later.
Thank you, sir. I have no questions. Commissioner Lindley?
No questions. Thank you.
Thank you.
Thank you, Commissioners. Ms. Smith.
Ms. Perales? Good morning.
Good morning. My name's Marisa Perales, and I'm here on behalf of Dharma Investments. And I'll be focusing my comments on two issues, and that is the subsurface geology and whether this is a commercial facility. I think both of these issues can be framed in terms of what we know about the on-the-ground, real-world conditions on the one hand, versus these theoretical, technical, mathematical arguments advanced by Altair and its representatives on the other hand. Now, regarding the real-world subsurface conditions, here Dharma is in a unique position because Dharma has conducted subsurface geological characterizations itself. It conducts gravel operations within Colorado County, and it owns a mine site within only a few hundred feet of the proposed landfill site. And the observations and experiences of Dharma are consistent with the aligned protestants and with the ALJ's analysis. And here's what we know. We know this site overlays the Gulf Coast aquifer, that the subsurface is complex and includes a variety of different soils and materials, including caliche, sand, gravels, clays, sandy clays, etc. We know that at various points on the site, the soils have a range of permeability values exceeding the 1 × 10⁻⁷ standard set out in the rules, even in those soil samples that were characterized as clay by Altair. We know that the site has been determined to be unsuitable by TCEQ's predecessor agencies in the past based on subsurface conditions. And we know that at some locations of the site, there's barely 10 feet of soil separating the containment structure from the aquifer. We don't know the in situ hydraulic conductivity of the materials under the site because despite TCQ staff's requests, Altair never conducted that analysis. There are portions of the footprint where we have virtually no information about the subsurface materials. That's in part because Altair started the process by relying only on 2 previously rejected applications that my understanding is Mr. Graves and Dr. Darling had no part of and did not observe the soil borings that were drilled for those applications. But rather than acknowledge these real-world conditions, Altair urges this commission to adopt a new policy, allowing it to rely on a calculation to demonstrate compliance with the standards in your rule. And that calculation they urge you to adopt is the geometric mean, because that's the only calculation that gets them to the result that they need. And that geometric mean depends upon hydraulic conductivity values from only the clay samples that were collected by them. I think they had only 1 sample that was not clay that had been sent to the lab for that analysis. So we have a very complex stratigraphic situation here. We have a variety of permeability values. It's worth noting that Altair bears the burden, and they bear the burden of proving an exception to the presumption, because the presumption is that this is an unsuitable site based on your rules, and they haven't met that burden. Now, on the commercial facility, here again, real-world conditions. Each trip from their incinerator to the landfill will cross Buffalo Bayou 4 times, the Memorial Park. It'll cross Brazos and Colorado rivers, pass by schools, and cross numerous roadways. The evidence indicates that each trip from the facility to the landfill could expose 100,000 people across 4 counties to hazardous materials. And yet again, Altair invites the commission to ignore these facts and risks and merely self-identifies as non-commercial. Acknowledging the commercial status of the facility best accomplishes the purposes of the regulatory distinction between commercial and non-commercial facilities. TCQ rules for non-commercial facilities were developed around a model of a production facility with an on-site dedicated landfill. This is the exception to the rule. So, for example, non-commercial facilities are exempted from full evaluation of transportation risks.
That's time.
I have one more sentence if I can wrap up.
You can wrap up quickly.
Thanks. I urge the commission to acknowledge its duty to recognize this facility as a commercial facility and hold Altair to their burden and hold them accountable for their failure to address the requirements of TCQ rules related to risks associated with this facility. Thank you.
Thank you, Ms. Perales. Any questions or comments
no
at this point?
questions. No, not this time. Thank you.
Great. Thank you. We'll hear from the executive director.
Good morning, Commissioners and General Counsel. On behalf of the Executive Director, I am Diane Goss, Staff Attorney with the Environmental Law Division. With me is Don Redman, also with the Environmental Law Division, and Sarah Schreier, a professional geologist and team leader with the Waste Permits Division. The Executive Director reviewed the technically complete application and the record of the contested case hearing. The Executive Director recommends the Commission adopt an order approving the application and issue the draft permit. As explained in his exceptions brief, the Executive Director disagrees with the analysis presented in the proposal for decision. The Executive Director agrees with the applicant's description of the proposed activities at Altair as non-commercial. Altair applied for a permit to authorize non-commercial, captive, hazardous waste management facility. The application was reviewed under the requirements applicable to non-commercial facilities. It would not be appropriate to act on the application by applying the rules for a commercial facility when the applicant did not seek approval for a commercial facility. The record does not support a finding that there is a practical, economic, and feasible alternative for disposal of the incinerator residue and thermal treatment residue wastes proposed for disposal at the Altair landfill. The record does not support a finding that there is a practical, economic, and feasible alternative that is reasonably available. The evidence at hearing addressed potential alternatives to the proposed landfill, but not one was shown to be practical, economic, feasible, and reasonably available. The record does support findings and conclusions that the application meets the siting and geologic requirements for landfills. These requirements are in 30 TAC sections 335.203 and 335.204. The executive director reviewed the geology report in the application and the evidence presented at the hearing. The record supports findings that the regional aquifer is separated from the base of the proposed landfill by a minimum of 10 feet of soil material with a hydraulic conductivity towards the aquifer not greater than 10 to the minus 7 centimeters per second, or a thicker interval of more permeable material which provides equivalent or greater retardation to pollution migration. The record supports findings and conclusions that the application waste analysis plan satisfies the applicable requirements for waste acceptance, characterization, and management required by 30 TAC section 335.152 and 40 CFR section 264.13. Additionally, the application identifies the known and potential sources, volumes, and types of waste that would be disposed. Finally, the record supports findings and conclusions that the application meets the requirements for traffic and transportation. Transportation of hazardous material over public roadways is regulated by the U.S. Department of Transportation. The draft permit requires Altair to take measures to assure that waste shipments are secured and covered during transport. The draft permit additionally requires Altair to implement its contingency plan for responding to release to the environment in the vicinity of the facility. And the application addresses traffic patterns near the facility, transportation of waste shipments to and from the facility. Thank you very much. We are available for questions.
Thank you, and I have none. Commissioner Lindley?
No questions right now. Thank you.
Thank you, and we'll hear from OPIC.
Good morning. I'm Pranjal Mehta. Dominique McLagan Brown is with me today. We represented OPIC in the hearing on this application. OPIC agrees with the ALJ's recommendation that Altair's application be denied. The evidentiary record developed through the contested case hearing supports the ALJ's conclusion that the application does not comply with a number of statutory and regulatory requirements. OPIC agrees with the ALJ's finding that the preponderance of the evidence establishes that Altair will be accepting waste for a charge and will not meet the exception that would allow the facility to be removed from the definition of a commercial hazardous waste management facility as set forth in the Texas Health and Safety Code and agency rules. We further agree with the ALJ's analysis on several additional issues. First, Altair failed to demonstrate that there is no practical, economic, and feasible alternative that is reasonably available to manage the types and classes of hazardous waste which might be disposed of at the Altair facility. Second, the record does not establish that the geology of the landfill contains soils that are sufficiently protective of surface water, groundwater, and the underlying aquifer. Third, the application does not adequately characterize the waste expected to be disposed of at the landfill, and the facility will not have on-site waste analysis capability to meet EPA regulations and industry standards for commercial hazardous waste landfill facilities. Finally, the application does not adequately describe the major routes of travel to be used for the transportation of hazardous waste to and from the facility. And the application does not provide adequate information on the potential for the public to be exposed to hazardous waste through releases associated with transportation to and from the facility. Also, the application does not demonstrate that the risk associated with the transportation of hazardous waste to the facility are compatible with local land use. In addition to the grounds for denial relied upon by the ALJs, OPIC agrees with the protesting parties that the draft permits stormwater and leachate management plan is inadequate. For these reasons, OPIC recommends that the application be denied. I'm happy to answer any questions. Thank you.
Thank you. I have none. Commissioner Lindley?
None right now, thank you.
Okay, I think we just have a housekeeping matter, checking the clock. Mr. Seal, I think you had used your time. I want to confirm whether that's true or not, and that part's true. And the protestants did not exceed their time? Okay, so we won't hear a rebuttal. Appreciate all the parties' presentations this morning. Commissioner Lindley, we have several issues to work through. For me, the geology predominates, and so I propose to lay out my thinking on that, then gather up your thoughts, and then perhaps we can chart a path forward on the other issues.
That sounds good.
Okay. So the applicants propose to place a landfill at or near grade, and this is in the Beaumont Formation, also called Unit 1. This formation is in the area that's relevant here, 20 to 25 feet thick, and it sits above the Chicote aquifer. And we, of course, have an obligation to protect that aquifer. And that requires geology that's sufficiently thick and sufficiently impermeable. And we have, TCEQ has two relevant requirements. The first is that within 5 feet of the containment, that the conductivity not exceed 10 to the minus 5 centimeters per second. And the second requirement is that somewhere between the containment and the aquifer, there's at least 10 feet of material that doesn't exceed 10 to the minus 7 centimeters per second. And what the applicants propose to demonstrate here is that there is 10 feet of soil adjacent to the containment that is protective as to 10 to the minus 7 centimeters per second. And that showing would satisfy both of our requirements. The problem here is that this Unit 1 geology is heterogeneous. So it includes clays predominantly, but it also includes sand, silt, gravel, and caliche. And it has, in fact, across the data points that were sampled, really highly variable conductivity. And that makes it somewhat challenging to demonstrate that there's actually 10 feet of material that is sufficiently impermeable. And the ALJ has considered a number of arguments about how to measure the sampling data against the standard, both in terms of what the standard is, as well as how to calculate conductivity. And we heard some of that in the arguments this morning regarding geometric mean. What is established is that among the 63 or so data points that were collected and fed into this calculation, some are well above and some are well below the 10 to the minus 7 centimeters per second conductivity standard. And as we heard, it is established that the average of the values exceeds our conductivity limit. And I'm referring to finding of fact 85. And to state that a different way, TCEQ's limit, and really we're talking about a speed limit, centimeters per second. TCEQ's limit is equivalent to 12 inches per decade, while the average conductivity is 2.5 feet per decade. But I think apart from the, how you express the standard or the formula, and more to the point, I think the data is insufficient here. The calculations include very few or no values for sand. The calculations include no values for caliche, despite the executive director requesting values for caliche. In addition, there are only 40 borings within the 66-acre footprint of the landfill. For many of those, there was no conductivity analysis performed at all. So ultimately, I agree with the ALJ's conclusion that the applicant has not met its burden on geology. I would need to have a much better understanding of this geology in order to grant this authorization. I think that would mean many more borings, a lot more data on conductivity. I think the incomplete data that we do have tends to suggest that this may be an inappropriate site for this particular facility. And for that reason, I think we should adopt the ALJ's proposed order denying the application, although I would do that with some significant revisions to the order, because I do have some issues with how the ALJs came out on some of the other issues. So
That's
those,
very
those are my
helpful.
thoughts
Yes,
as
thank
a
you.
Initial stab at this. And
Right. My initial thoughts are not far off. My overall take on this is that while I do disagree with some of the ALJ's analysis and their interpretations of some of our regulations, I agree that the record we have before us today supports the ALJ's ultimate recommendation to deny based on geology. At the end of the day, as it's been stated today, our job is to ensure that this hazardous waste fill is protective of human health and the environment. And based on this record, I'm not fully confident that the proposed landfill will be protective in respect to the geology. And one other note I just want to make for, I guess, people that might be tuning in for the first time for this is that as a commissioner, we are only able to consider and look at the information evidence presented in this record. And so the only way to overturn the ALJs is to find that great weight of evidence clearly goes the other way. And I didn't find that for the reasons you stated, the geology being the main one. So that's all I'll say for now.
yeah, I appreciate that point. I mean, and what I'm going to propose to do is not to adopt the proposal for decision. I'm not doing that today, nor am I adopting, as I suggested, the entirety of the ALJ's analysis. I'm proposing to adopt only those findings of fact, conclusions of law, and ordering provisions that we agree to.
I agree.
But to restate your point, this is not the order that I would propose is not the order that I would draft. So, for example, it's going to include findings of fact which will remain there because they are true, even though they're wholly irrelevant to my analysis. So
There are few that I might agree with you like that on.
okay. What I might
Go ahead.
propose,
Okay.
and I'm happy to hear your thoughts,
go ahead.
is I have a marked up order that I
Okay.
thought we might use as a tool
That's good.
to address the issues.
Okay.
And
I also have one.
okay, why don't we lay them side by
Yes.
side, and we can just work through it. That's mine, I guess.
Yes. Okay.
Okay, this is
Ooh.
all right.
Is that mine? That's yours. I brought mine. Okay. Thank you.
Okay, and Commissioner Lindley, I propose that we take this sort of topic by topic, and I do have some thoughts on how to finish out the piece on geology.
Okay.
Okay.
Do you want to start? Would you like me to start?
Yeah, I'll go ahead and start.
Okay.
So let me just give me a moment to open
Yeah.
our respective orders here. I'm going to start at findings of fact 78.
Before we start, we're circulating to the parties an order that is not marked up in the hopes that that would help people follow along with what's going on.
All right.
You're starting with what number?
Okay,
78?
so I'm looking at 78, and actually 87 has the same explanation. I'm proposing to simply modify those to reflect that the evidence on which those findings of fact rely are really the testimony on 78, just to indicate that it was TCEQ's geologist that testified to the facts stated there, and then in finding of fact 87 that it was TCEQ witness that testified about the geometric mean.
I agree. I had the same notes. I think both of those finding of facts,
Yeah,
78
those
and
look very,
87.
very similar. Okay.
That way they're more consistent with the evidence.
And then the next change that I would have is on finding of fact 85. And this was just simply to correct what I think was a typographical error. The median value is 1.30 times 10 to the minus 8, not 1.81.
Yes.
Okay. And I have no changes with respect to geology on the conclusions of law. Did you
Let me
have
get to that
anything?
section. I do.
Okay.
And I can, well, let me see here. Where does that section start?
I think it's less well defined on the conclusions of law.
Yeah. Well, maybe I. Is that kind of starting right here? Okay. I don't have any on geology.
Okay.
I have them in a
yeah,
different place.
I wasn't seeing any. Okay, so I think that closes out
The minor.
geology. So in the background section, I have just one correction on finding of fact 7, which has already been noted. I think we're changing a 6 to a 7, right?
Correct. That
Okay.
came from the ALJ's letter.
Right.
Yes.
So we have the same thing there. Okay, so I believe we're done with background.
Yes.
That takes us to the issue of commercial, non-commercial. And I do agree with the ALJs that the applicant failed to meet its burden to prove that the facility would be non-commercial, but the evidence was inconclusive. I disagree that it establishes that the facility is a commercial facility.
I would agree, and just to add on to that some of my thoughts. You know, Altair had a burden to establish at the hearing that the facility is non-commercial and captive and that it meets the owner exception. And there's just a little bit of, there's not significant enough evidence to overturn the ALJ, while I think there are edits that need to be made to the findings of fact, because I am not making a determination today that this type of facility in general could not shown to be, let me say this right, could not be shown to be non-commercial. It was just the burden of proof was on the applicant, and I find it inconclusive in order to make that determination.
I agree. It remains an open question.
So I can start with my edits?
Yeah, that's great.
Okay. I would start with number, finding of fact 48.
Okay.
I found that I think it should be deleted, 48 and 49. I think that neither are supported by the great weight of evidence, and for 48 in particular, it's not material to an applicable regulation. It looks like you.
I agree with
have
that.
the
And
same markings.
I struggled a little bit with the word extension too. I think that was not particularly meaningful or helpful, but I agree with those.
Next, I found that some edits needed to be made on finding of facts 52 to 55. I would recommend that they all be deleted. I'm not willing to go so far as the judges did in their interpretation of charge. Again, it falls in the, but the weight of evidence isn't there to overturn it. So I recommend that we just delete them.
I agree with deleting them because the evidence, I think, is doesn't support them. Yeah, agreed.
Next, in this section, I'm proposing a deletion of finding of fact number 64, 65, and 66. I do not believe they are supported by the great weight of evidence. Sound redundant probably, but
I agree.
that, I believe, covers the non-commercial, commercial portion?
With respect
Unless
to
you
the
have
findings
other-
of fact, I think that's correct.
Yes.
I think it implicates conclusions of law
Yes.
8 and 9, however, so try to recall what I've done there. Let's see what you've done there.
I had some proposed changes, but I'm willing to hear yours first. Or I'll jump to yours first.
This is just basically overturning the conclusion. You know, again, I think the evidence was inconclusive, and so on 8, I would modify conclusion of law 8 to say that Altair failed to prove by a preponderance of the evidence that the facility would be a captive facility, and for conclusion of law 9, that Altair failed to prove by a preponderance of the evidence that the facility would be a non-commercial hazardous waste facility.
I agree with those edits.
Okay, and that is all that I had on the commercial,
Yes.
non-commercial.
I believe that's all I have as well.
Okay. Alternatives analysis. What do you think?
Just double checking. I had a few edits. It looks like we might have the same for 67, 68, 69. I believe that an edit needs to be made, some clarifying language. So each of those 3 sentences should read, at the beginning, Altair did not adequately evaluate. Altair did not adequately, evaluate on all 3.
Yeah, I had similar thoughts on that, and your edits accomplished my purpose. So
I think it makes it more accurate.
Yeah, I agree with your changes to findings of fact 67 through 69.
I do have thoughts on finding of fact 70 to 72.
Okay.
And I'm proposing that we delete them. I don't really believe that the finding of facts are supported by the great weight of evidence, that it's the record isn't sufficient enough to make a determination on these, and I don't think it's material to the applicable regulations. I don't know if you have thoughts on that, or
Let me turn to those.
sure. I think that, just to add on to that, to give a little more context,
Yeah.
I think there's sufficient evidence in this record to support the ALJ's determination that the application failed to meet its burden of proof in the issue, but some of those findings go too far in making conclusive determinations. And like I said, implying specific regulations that are not, implying specific requirements that are not in the regulations. And so.
That makes sense to me. I actually had not flagged those, but I'm fine with your deletions of findings of fact.
That's
70 through 72. And then I think those changes implicate conclusion of law 10. Actually, no, I think my change to conclusion of law 10 was just to track the statutory and regulatory language
make sure
a little
yours
bit more
looks like
closely.
mine.
It's a lot of paper to be flipping around
is.
here.
I agree with your edits to conclusion law number 10. I did have one.
Great.
Oh, go ahead. Sorry.
Good. I'll take it.
I had one question on numbers, finding of fact number 74 before we leave this
Okay.
section. I wanted to get your thoughts. I don't. What I would propose is a possible deletion, and only because I think it implies a duty for the executive director to evaluate something that's not expressly stated in the applicable regulations. At the end of the day, I'm not sure it really affects a conclusion of law, but in an order of, just in the manner of keeping it clean and tight, I thought about deleting it. I really wanted to get your thoughts on it more than anything else.
Yeah, that's not one that I had flagged to change or delete. I think that the applicant certainly has an obligation to present some form of an analysis, and in evaluating an application, I think the ED has to do something with that analysis. So, exactly what is submitted and the quality of
Right.
submitted. I don't think we need to weigh into that
Okay.
today, but I think I would, since it's
I mean, it's true that
since
there
it's
was no
true,
evaluation done.
even though it wouldn't be part of the orders I would write it, I propose we leave it in.
Okay, I'm fine with that. I kind of want to just talk through that one.
Yeah, appreciate that. I think that closes out the
I-
alternatives analysis.
I believe so. That's all I have noted for myself.
Okay, next up, financial assurance. I agreed with the
I have-
findings of fact and
Oh, sorry,
conclusions
go
of
ahead.
law on that. I didn't have any changes to financial
I'm
assurance.
double checking that I did not. No, I have no changes.
Okay, waste analysis plan. I'm happy to take the first stab at that. The plan and the waste characterization.
Sure.
Okay. I think the ALJ's reading of 40 CFR 264.13 is clearly erroneous. I agree with the argument that on-site waste analysis is not required, that the generator may provide the analysis, and that additional analysis is only required if there's a discrepancy between what's observed in the load and what's on the manifest. I think the evidence also shows that the waste analysis was adequate to represent the types of waste that would be or could be accepted. So I would reverse the ALJ on that. I would strike, or I would revise the order with respect to findings of fact 97 through 99, and let me flip to those so I can recall exactly what I'm proposing to do with those particular
And while you're flipping,
findings.
I will just say that I agree that I agree with you, and I disagree with the ALJ's
Okay.
interpretation.
So the edits and they were just merely edits, well, more than edits, edits that accomplish overturning essentially the findings of fact on 97 and 98. And then I'm proposing to strike finding of fact 99.
Yes, I agree. Yes, that's all the edits I had.
Okay. And conclusion of law 17 concerns same topic.
Yes.
One of the parties, I think, or perhaps the ALJs, had caught a transposition error.
Mm-hmm.
The 6 and the 4, so we'll get that corrected.
And change it to read, I have noted Altair proved.
Yeah, that's
my
good.
edit.
That's good.
Okay.
Essentially going the other way on that particular conclusion.
Correct.
Okay, and that's all I had on waste analysis and waste characterization.
That is also all I had.
Okay. I agreed with the ALJ's findings of fact and conclusions of law with respect to the liner, the cover, stormwater, and leachate, and I did not have any changes in any of those sections.
I agree. The next set of changes I have fall under traffic and transportation requirements.
Okay, what do you got?
The edits I have are, I tend to disagree with the ALJ's interpretation of the law on the issue related to exposure information requirements. And I propose overturning the ALJ's determination on this issue. The exposure information requirements in 30 Texas Administrative Code, Chapter 305.50 A8, as interpreted by EPA guidance in the record, requires a submittal of information concerning transportation to and from the unit, including on-site transportation and transportation in the immediate vicinity of the facility.
Yeah.
The EPA guidance speaks to the immediate vicinity as being access routes within a distance of 1 mile. And so because of that, I do not believe that the record, including the applicant's Exhibit 8, supports the ALJ's interpretation. The exposure information report must include transportation routes all the way back to the Deer Park facility. So I would suggest that we delete findings of fact 115, 116, and 117.
Okay, let me turn to those.
I think they imply that the evaluations, well, I think that they exceed the exposure report rules and guidance.
I had not flagged those, but I think that's fine to do that, so I agree. And then additionally, I want to see if I had picked up additional findings of fact that need some work.
Yes.
At 122 through, I think all the way through 128. Let me turn to that. On 122, I would just simply strike the word briefly. It's in the top line towards the end.
Okay.
And then I would delete finding of fact 123, and I would delete 125 through 128 for the reasons that you
Yes, I had the same
expressed.
Notations to delete 125 through 128. Did you discuss 124?
Not yet.
Okay.
I think on that one, we both had some edits. Let's
Yes,
see how
it
they
looks
line
like
up
it.
here. I think ours look very similar, and they both go
So-
to.
I'm fine with the language in yours. I
Okay.
think they're similar enough.
All right, thank you. I think that closes out the findings of fact on traffic, transportation, and land use.
Yes, that does for me.
You may notice in mine, in my markup, I was entertaining the possibility of adding another finding of fact, and I've decided I'm not going to propose
Want to
that. I
include
think it's
that?
I think it's
Okay.
unnecessary. What it goes to is the failure to submit a map showing land use patterns. I think there was, in fact, that failure to submit the map that's required under section 305.50A10D, but I don't think it's necessary to the order, so I'm not going to.
So you'll have 130 to 137, as the order will remain.
The order will remain as it is. I just wanted to bring that to your attention because you may notice in my document I had this other
Yes,
finding of fact
yes.
that I've decided not to
Okay.
propose to include.
Thank you for that clarification. The next, the only other edit I have as far as the rest of the finding of facts is on finding of fact number 142.
Okay.
I believe it needs a little clarifying language or clarifying change to add the words except for the exposure information report to more accurately reflect the evidence and testimony in the record.
Yeah,
So I would just add that on
Yeah, I think that's fair.
after Colorado River, except for the exposure information report.
Okay. I think that's helpful. And let's check for loose ends here. Got a couple things in the ordering provisions that need attention. I don't think we talked about conclusions of law as they
Oh,
relate
no.
to traffic and
Sorry, I skipped
transportation
that.
and land use. So I think we're beginning at least on mine, on 19. Conclusion of law 19.
Yes, that's the next.
Trying to get yours
Edits
open to
I
the
need
same
to-
page.
I believe our edits look similar.
Yeah, we're basically, well, hold on a second.
We were saying that it does meet the requirement.
Right. We're basically reversing on
Yes.
119. And then it looks like we both proposed to delete 21 and 22.
Yes.
Okay. And I think that takes us to the ordering provisions.
Yes, sir. There was one I thought I would ask you about as well. Sorry, on the conclusions of law number 23. I wonder if there needs to be either a modification or something. I think it's accurate, but it may implicate or exceed, again, some of those requirements that are not expressly required by land use regulations. I don't know if you have any thoughts on it.
You actually caught me a little cold on that one.
We can come back to
I
it.
had no thoughts on it.
Or yeah. Well, I don't, it will not make or break the conclusions of law for me. I'll put it that way. I just wanted to bring it up. I'm just trying to keep this thing as accurate and as clean as possible, in my opinion. And if you want to take a minute, we can come back to that one in a little bit.
Yeah, let me propose this. I think we're
Getting close.
We're remarkably aligned. I think we're
Yeah,
close. I'm going to propose that we talk about the ordering provisions.
That sounds good.
And then maybe take a recess.
That sounds great.
To
Let's do that.
craft a motion. That'll give me, and during that recess, I'll do my homework on this number 23.
Okay.
And then we can come back after that.
Let's see.
So ordering provisions.
Yes, it looks as though we have jotted down similar findings.
Yeah, I'm not surprised that we're,
Yep.
based on your comments, that we're both proposing to strike the language directing the issuance of the permit.
That's true.
And we both had a similar additional order concerning adoption of the response to comment.
Yes.
And I'm fine with the way that you've articulated it.
Okay.
So, I believe that we are on the same page on what the order would look like, with the possible exception of that number
Conclusion of law
23.
23.
Conclusion of law 23 that we had flagged.
And maybe it just needs a small modification. Maybe it doesn't need anything, but take a look, and I'd like to get your thoughts on it.
Do you have any
I
language
don't
that
in
you
front
would
of me right now, so I would
propose?
need a minute
Okay.
to.
All right.
work on
So
that
why
as
don't we
well.
take a recess? That'll give us an opportunity to begin putting together a motion, do our homework on conclusion of law 23, and then we'll regroup after that.
That sounds good. Thank you.
How much time do we need? How much?
10 minutes? 10?
Why don't we recess until, so it's, I've got 11:12 right now. Let's recess until 11:30.
Okay.
We stand in recess.
believe so. Oh,
All right, the time's 11:30. We're back in session, and Commissioner Lindley, what I'd like to do, I think, is we'll talk about this conclusion of Law
Sure,
23, and then I had prepared a motion,
Okay.
and with the help of my lawyers, tracking our conversation,
Okay.
had that marked up, and
I should be able to follow you on the notes I took, so it'd be fine with
yeah,
your motion.
why don't we do that?
Yeah.
So I'll read it slowly when we get to
Okay.
when we get to that point.
And, well, sorry, go ahead.
I guess that's all I had.
Well,
You want to talk about conclusion of Law 23?
I
or-
will. I'll make it pretty quick. I'm not going to propose a modification. I'm going to just suggest we leave it in. Technically, it's accurate, the conclusion of Law 23. I was just apprehensive because I don't want to agree with anything that may be an implication that the requirements, or that we're requiring anything that exceeds the requirements. I guess is the best way to say that are not expressly required by the land use regulations. So that's really the only point I wanted to make. At the end of the day, it is technically accurate, the conclusion of law. So I'll back off my modification or deletion suggestion and propose that we leave it in.
I agree with that, and I think it's helpful that we've had the discussion. The land use map that I mentioned earlier, the omission of that map alone makes this a correct conclusion, although I think we probably agree that the ALJs had a lot more in mind about what was loaded in this than we do, but since it's an appropriate conclusion, I agree that we not touch this one.
That sounds good, and I will try and follow your motion.
Okay. Commissioner Lindley, I move that we deny the permit application of Altair Disposal Services LLC for hazardous waste permit number 50407, that we adopt the executive director's response to public comment to the extent that is not inconsistent with the commission's decision to deny the application, and that we adopt the ALJ's proposed order with the following changes. A, adopt the ALJ's recommended typographical corrections to proposed finding of fact number 7 and conclusion of law number 17 as set forth in the ALJ's June 27, 2019 letter. B, replace 1.81 with 1.30 in the last sentence of proposed finding of fact 85, as it appears to be a typographical error and should be consistent with page 22 of applicant's supplemental exhibit number 3-3.
Okay.
C, delete, quote, and issue the attached permit, end quote, in proposed ordering provision number 3, as it is inconsistent with the ALJ's recommendation and the commission's decision to deny the permit. D, add new ordering provision number 3A to reflect the commission's adoption of the executive director's response to public comment to the extent that it is not inconsistent with the commission's decision to deny the application. E, regarding the insufficiency of the record on the commercial nature of the proposed facility, delete proposed findings of fact numbers 48, 49, 52 through 55, 64 through 66, 70 through 72, and 126 through 128.
Yes.
And overturn proposed conclusion of law numbers 8 and 9.
Yes.
And 21 and 22.
Yes.
As the findings and conclusions are not supported by the great weight of the evidence and are not material to the applicable regulations. F, regarding alternatives, modify proposed finding of fact numbers 67 through 69 to add the word adequately before the word evaluate in each finding to more accurately reflect the evidence and testimony in the record. And replace proposed conclusion of law number 10 with the following, quote, Altair failed to prove by a preponderance of the evidence that its application is consistent with the prohibition against issuing a permit for a new hazardous waste landfill if there is a practical, economic, and feasible alternative to the landfill that is reasonably available in accordance with Texas Health and Safety Code Section 361.106 and 30 Texas Administrative Code Section 335.205A2, end quote, to more accurately reflect and track the language in the applicable statute and rule.
Yes.
G, add the phrase, quote, TCEQ's geologist testified that, end quote, to the beginning of proposed finding of fact number 78 to more accurately reflect the evidence and testimony in the record. H, modify finding of fact number 87 to read, quote, TCEQ witnesses testified that they were unfamiliar with the use of the geometric mean to characterize soil data in any other permit application for a new hazardous waste landfill approved by the executive director or the commission, end quote, to more accurately reflect the evidence and testimony in the record. I, regarding waste characterization, overturn proposed finding of fact numbers 97 and 98. Delete proposed finding of fact number 99.
Yes.
And overturn proposed conclusion of law number 17, as the findings and conclusions are not supported by the great weight of the evidence, mischaracterize the evidence in the record, and are clearly erroneous in light of precedent and applicable rules. J, regarding the exposure information report, delete the word briefly in proposed finding of fact number 122.
Okay.
Delete proposed finding of fact numbers 123 and 125, as well as finding of fact numbers 115 through 117.
What did you say for 124? Modify?
So I had just
Okay.
addressed deletions.
Okay, go on then, sorry.
With respect to finding of fact 124, reword proposed finding of fact number 124 to read, quote, Altair evaluated the potential for the public to be exposed to hazardous waste from releases from the transportation of waste to the unit on site and in the immediate vicinity of the Altair facility, end quote.
Yes.
And finally, with regard to the exposure information report, overturn proposed conclusion of law number 19 because the findings and conclusions just described are not supported by the great weight of the evidence and are inconsistent with EPA exposure information requirements guidance contained in the record.
Yes.
And finally, K, add the phrase, quote, except for the exposure information report, end quote, to proposed finding of fact number 142 to more accurately reflect the evidence and testimony in the record. And that ends my motion, and take as much time as you need
Okay,
to
thank you.
make any comments or second you want to make.
I believe that covers everything. I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, I think that takes us back to item 33.
That's correct. Item number 33 is our public comment session, and currently we don't have anyone signed in to speak. So that takes us to the end of the items posted for open session. Items 34 through 37 are for closed session, and the commission will not meet in closed session today.
The time is 11:40 and we are adjourned.